السلام عليكم ورحمة الله وبركاته. بسم الله الحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه ومن والاه. اللهم لا علم لنا إلا ما علمتنا إنك أنت العليم الحكيم. اللهم علمنا ما ينفعنا وانفعنا بما علمتنا وزدنا علما وأرنا الحق حقا وارزقنا اتباعه وأرنا الباطل باطلا وارزقنا اجتنابه وأدخلنا برحمتك في عبادك الصالحين آمين يا رب العالمين. Ahlan wa sahlan. Welcome everybody to another lecture on the Fiqh of Financial Transactions. Of course, we are studying from the book Akhsar al-Mukhtasarat, a beginner fiqh book in the Hanbali madhab. And alhamdulillah, we are past the half line and we are doing now the Fiqh of Financial Transactions, Fiqh al-Buyu' wal-Muamalat. And الأسبوع الماضي we started talking about عقد الإجارة, right? The Ijara contract. And quickly, let's quickly review what we covered. Today, inshallah, we want to cover the rest of the section on Ijara. When we speak of طبعا Ijara, when we speak of Ijara, what does Ijara mean? Who can tell us in their own words معنى الإجارة? تفضل. Yeah, it's a rental or a service like hiring, leasing. All those words come into under the نعم. Well, not all of them. You're saying for a specific time. So Ijara, we said it's basically a rental or leasing contract. And we said that there are conditions for them. For them to be valid, we said there are conditions. We mentioned three of them. Who can remind us the three conditions? نعم. No, you're talking about specifics. We're talking in general. Okay, it's a rental contract. Naam? Okay, those are conditions for like renting an asset or a property. But in general, like a rental contract, we said that rental contracts or ijara, it's bay al-manafi'. Okay, it's a transaction for the user fruct or benefit. It's bay al-manafi'. So the manfa'a, the first condition, obviously, the manfa'a has to be first before it's halal. It has to be known. Like if you're gonna do a contract, it has to be known. What's the contract for? Okay, is it for residence? Is it for car rental? What is it? What's the manfa'a? What's the benefit that I'm getting from this? Like, what am I paying for? Tamam? I'm hiring someone to do a job. Okay, what am I hiring for? Right? So that's how I'm gonna pay them. I'm renting a property for what reason? The manfa'a has to be known. It has to be known. Otherwise, the contract is not valid. Tamam? So that's the first one. The second thing is that the manfa'a has to be halal, has to be mubah. Okay? So the manfa'a has to be mubah. It cannot be haram manfa'a from what I'm renting or leasing. Tamam? And the third condition was what? Na'am, the price should be known. Yes, we mentioned that the price should be known. There should be a price that is mentioned in the contract. So three things. We said there has to be the user fruct or manfa'a has to be known. The user fruct or manfa'a has to be mubah. And the third thing, you have to have the price mentioned, the ujra. And then we said there are two types of ijara. What are they? One type is where you... Yeah, so there's a rental contract for a property or an asset where you are getting benefit out of it. Tamam? I'm renting a car, I'm getting benefit for transportation. I'm renting a house, I'm getting the benefit or the manfa'a of living there. Okay? And the other type was a service, right? I'm paying someone to cut the grass. I'm paying someone to, remove my molar teeth or something. Or I'm paying someone, whatever it is. Okay, so those are the two types of manafi'. When we're talking about rental properties, we said that there's two ways to kind of make the contract. By time and by task. Naam. So it could be by time or by task. So it could be مثلا for 1 month, okay? I'll pay you I'm going to charge you for 1 month, okay? Or it could be that it's for a specific task. You get the task done, regardless how long it takes, you will get paid once the task is done. Tamam? Or once the task is done. Jamil. طيب, now we go into the second part of Ijara. And this probably should have been mentioned earlier, but the mu'allif he delayed it for a bit. And so he says here, فصل في لزوم الإجارة وما يجب وما يوجب الفسخ. So he's talking here about the type of aqd that it is, okay, and what causes it to break or to be void. فhe says here, رحمه الله, وهي عقد لازم. This is going to keep coming. I told you guys, we have to make sure that we understand this is aqd jaiz or aqd lazim. And we said that jaiz means it's not binding. It's a non-binding contract, meaning any one of the two sides could leave, okay, could break the contract. Like could be like, khalas, I don't want to do it anymore, okay? Like we talked about wakala and other contracts like that. They are jaiz. They're not lazim. This one, aqd al-ijara, is lazim. إيش يعني لازم? يعني it's binding. Meaning that none of the two sides can break the contract unless for some valid reason. Okay? جميل. وهي عقد لازم. So then he says, فإن تحول مستأجر في أثناء المدة بلا عذر فعليه كل الأجرة. فإن تحول, يعني he's saying that the مستأجر, the lessee, okay, the lessee. Let's say we're talking about a rental property. So the مستأجر, the one who's renting, okay, the lessee, the one who's renting, okay, if he decides to, they signed a contract for 1 year rental. You signed a contract with your landlord for a 1 year rental. فإن تحول مستأجر, if the مستأجر, the lessee decides to, you know what, I want to leave after 4 months, okay, في أثناء المدة, يعني in the middle of the time period that they agreed on, بلا عذر, without a valid reason. What could be a valid reason here? He's traveling? Is that a valid reason? Give me a valid reason. Like, what's a valid reason? A valid reason could be something like, okay, for example, he says, khalas, I lost my job, I can't pay you the rent, and I need to leave the country. Okay, obviously then, khalas, that's a valid reason. Now, tafadhal. Living somewhere else, but you have a contract. So unless you have a valid reason, right? I'm not talking about if the landlord is going to forgive. No, I'm talking about just if the landlord decides, no, I'm not going to let you go. But nowadays, if you have a lease with a landlord, you have to finish the lease, right? Sahih. Now, if you go to him and be like, listen, man, XYZ, I got a job in Edmonton, blah, 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 okay. I have to go travel and move there. And he says, you know what, no problem, man. ما في مشكلة, okay. Some landlords will say, some lessors will say, find me someone to take over your contract and I'll pardon you, okay. But what's he saying here? فإن تحول مستأجر في أثناء المدة بلا عذر فعليه كل الأجرة. So we signed a contract for 12 months. You only finished 6 months. And now you're like, you know what? I found a better rental. Is that a valid excuse? No, it's not a valid excuse. Are you responsible to pay the rest of the contract? You're responsible to pay the rest of the contract. Okay? So this is important to understand. Unless the landlord excuses it. Other valid reasons could be, مثلا, the house is it's leaking and the guy refuses to fix it, right? And we said before last week that it's from the urf, okay, it's from the custom that the landlord, he's the one responsible to fix those things, unless you are the one who caused the damage, unless you're the one that caused the damage. تمام? So بلا عذر فعليه كل الأجرة. عليه كل الأجرة, he has to pay all of the rent. Jamil, so that's the first important point. فإن حوله مالك فلا شيء له. So now he's talking about the malik. The malik is the landlord. But what if the landlord decides, you know what, I'm breaking the contract? First of all, first question, is he allowed to do that? Let's talk about Sharia and then we'll talk about like the laws here in the land here. So is he allowed to do it? No, it's binding. Aqd lazim. So he's not allowed to break the contract. Okay? If he breaks the contract, he's athim. Okay? It's a sin. He's not allowed to do that because this is aqd lazim. Faddal, you have a su'al?
What if
So nowadays in contracts, so let's go now to now in contracts, like I think there are like they'll write things, مثلا, or maybe it's the law of the land. If مثلا he's selling the property, or he has to give you a notice, مثلا, of 3 months. Is it 3 months here? Is it 3 months for you to, huh? Okay, so it's not like something in stone, yani. But most of them they'll put like 3-month notice, right? If they want to evict you, or they want to ask you to leave, the landlord has to give you, I think, 3 months at least. I think this is law, by the way. I remember reading it somewhere.
The tenant is not paying, but if the tenant is paying, both of them are bounded by the contract.
So both of them are bound by the contract. طيب, so what he's saying here, وإن حوله مالك فلا شيء له فلا شيء له يعني للمالك. So if the contract is 6 months, and it's like 6 months in now, and the landlord wants to break the contract, does he have a right to take the rest of the 6 months? No, obviously, right? That's what he's saying. Yani, maybe you're saying obviously, but because the author is trying to make it clear. Okay, if the renter is the one who broke the contract, then he has to pay the rest. He has to pay the rest. Okay, but in the case where the landlord breaks it, okay, the renter does not have to pay. Okay, that's what he's trying to make clear. But obviously here, you can't cancel. None of them can cancel unless they have a really a valid reason. And also, in more advanced books, they'll go into the mas'ala of that. What if the landlord cancels, the malik cancels the contract? It's a lazim contract. So we're going to say, okay, huwa athim, and the qadi actually might make him liable for any damage or, financial burden that will be on the renter. كيف يعني? The renter, he's renting, mashallah, okay, and he signed a 1-year contract. But you come to him 6 months and you break the contract, and now this guy has to, he can't find something this fast, so he has to go to a hotel and expenses, so the landlord will be liable for that. Tamam? Yeah, in that period. Now, how is that fixed? Is by putting stipulations of, مثلا, if in case of this happens, or I'll give you 3 months. That's why here they'll give you مثلا 3 months or 6 months to find a place. In Alberta, in Calgary, if your lease is over, the landlord has to let you know 3 months in advance, right? If you're going to renew, صح? Is that right? They'll give you like a notice. I think they'll give you a notice, and they can either increase the rent here in at least here in Alberta. They have to give you, I think, 3-month notice or something like that. During the contract, no, but before the renewal, I think I remember I read in the what do they call it? On the Alberta website that they have to let you know 3 months in advance if they want to increase the rent. That's another mas'ala. طيب. Jamil. Cool. So let's read. Bismillah. So the ijara is a lazim type of contract. Okay. So lazim meaning it's binding, and neither party can back out of the contract without permission from the other. طبعا, if both of them sat down and they're like, you know what, I want to break the contract. You okay with that? Sure, no problem. ما في مشكلة. Nobody has any problem with that. Jamil. So both parties become committed until the end. If the lessee, the renter, is the one that cancels before the contract's term is up, then he must compensate the lesser, the landlord, for the rest unless the latter agrees to forgive it. Right? If he agrees to forgive it, ما في مشكلة. طبعا, here we're talking about renting like a rental property, but this applies for all types of ijara. So the example here, Muhammad agrees to rent out Zayd's apartment. So Muhammad is the lessee. And Zayd is the landlord, the lesser, okay? For 6 months at $500 a month. However, after 3 months, Muhammad decides to cancel the contract. In this case, Muhammad must still pay Zayd for the remaining 3. He still owes him how much? $1,500. He has to pay him that $1,500 unless there's a valid reason. If the lessor, the landlord يعني, is the one that cancels before the contract's term is up, then he gets nothing. He's not gonna get the rest of. So in this case of Muhammad and Zayd, if Zayd is the one who cancels 3 months in, then Zayd does not get any money. The landlord does not get the rest of the money for the contract.
Because he has to pay the remaining in one shot, or he can pay it in.
Who Zayd? Muhammad. Oh, Muhammad who breaks the contract. So does the lessee have to pay all of it in one shot? Wallahi, that depends on the agreement they have. But it is due upon cancellation. And it's due upon cancellation.
The contract is 1 year.
I understand your question. You're saying that, well, let's talk about this case. In this case, it's a 6-month contract. He finished 3 and he decided to cancel. Okay? He owes 1,500. His question is, does he have to pay the 1,500 in one shot, or can he pay it monthly? Wallahu a'lam. It seems like if he did it monthly, it should be fine. Because that was the agreement initially. Sah? That was the agreement initially. It seems like that would be the reasonable thing. I don't see anything that would... but would the landlord be able to say, give it to me all at once? I don't think so, because the contract says that it will be paid monthly. Now, if the contract, like in some countries, like in Saudi Arabia, مثلا, they have 1-year contracts where you pay every 6 months. Like they'll have a stipulation, مثلا, if you want to pay in 6 months, I'll charge you 18,000 riyals for a year. Okay, 9 and 9. Okay, and if you want to do for monthly, okay, I'll charge you 20,000 for the year. Okay, do you understand the difference? So it depends on the aqd. There might be some shurut in it. Tfadl.
In Iran, there's a different type of contract.
In Iran, you said?
Yeah, Iran.
Okay.
When you go there, they lease you the house, let's say. You pay the whole duration of your stay there. Let's say you stay for a year or 2. And after you go out of the house, they will pay it all back to you.
So you're saying in Iran, there's a type of rental contract?
Most of it is like that.
Okay, so what do? The renter?
As a renter, I will pay you, you are the landlord, 12 months for this year. Let's say $55,000.
Okay, so you pay for the whole year one time, upfront.
And then you go do business with that money. And then after...
The landlord will take the money and do business with it.
Exactly. And after I finish, you pay me back the 5,000.
We talked about this.
So using the money
So just so the listeners understand. So basically, I'm the renter. I pay the full year rent. Okay, let's say it's 1,000 a month. So I will give the landlord 12,000. Okay, we signed the contract for 12,000. The landlord now can go use that money to do business, but he has to give it back.
after you leave.
Yeah. So this is basically what? Huh? No. But like, no. Okay, let's look at it from both sides. Is he allowed to use his money like that?
There's one more thing.
Okay. So the condition is that you give it back. What if he loses the money? Does he still?
They will give it back. And
So it's a dain. It's a dain. It's not a aqd. It's not an ijara. Call it ijara if you like, but this is a dain with a manfa'.
most of the time they use it in riba.
No, but isn't okay. So we covered debt, right? We covered debt before, and we said that riba. The definition of riba is a loan with a benefit. صح? Isn't that what we said? I'm gonna lend you. You need $5,000. I will say, go ahead, here, take $5,000. But when you give it to me in 1 month, okay, give me I don't know, a car with it or something like that. That's a manfa'a. I intentionally didn't put 6,000, like an extra 1,000. So you don't just think it's money. It's also any manfa'a, we said. So any benefit. So if I tell you, I'll let you borrow the $5,000, but you have to pick up my son from the Islamic school and drop him off for the next, for the next month. That's a manfa'a, that's a riba. You picking up my son is riba, okay? It's not allowed. So here, you can call it ijara, but what's happening here, you are actually giving the landlord money, okay? And so you're renting him the money, and you're getting a manfa'a of renting, of staying in his place, okay? And he is also benefiting from your money. Is this riba or not? Is this riba or not? It is riba, right? It's riba. It's riba because you're getting a manfa'a out of a dain. So the landlord is getting a dain, and he has to bring it back. So it is a dain. By definition, by the way it's being used, it's a dain. Jamil. Okay, so don't rent an Iran. طيب, let's move. So we finish by Aisha, inshallah. So then he says here, طيب, now he's going to talk about when is it void. When is the contract voided? Because it's aqd lazim, so there has to be some reasons for the aqd to be voided. So he says, وَتَنْفَسِخُ بِتَلَفِ مَعْقُودٍ عَلَيْهِ وَمَوْتِ مُرْتَضِعٍ وانقلاع درس أو برئه ونحوه. طيب, he says وتنفسخ, the contract is voided, or it's invalid. It becomes invalid or voided for three reasons. He says, number one, بتلف معقود عليه. التلف is like damaged or it's lost or whatever it is. So المعقود عليه is the property or whatever the contract is on. So let's say you're renting an apartment. Okay, so let's say like there's an earthquake and the floor collapses or something. So now the ma'qud alayhi, the actual property, is damaged. So now this would break the contract. Or for example, the roof falls, or you're renting a car, okay, and then I don't know, the engine stops. Naam? Yeah, transmission is gone. What happens? The aqd is voided. The aqd is voided. So that's number one. وَمَوْتِ مُرْتَضِعٍ. You'll notice in the books of fiqh, they always talk about this because it's very common, right? The wet nurse, right? So let's say you hired a woman to breastfeed your child, okay? And the murtadi', who's the murtadi'? The baby. The murdi'a is the wet nurse. The murtadi' is the baby. So and then the baby dies. So khalas, the contract's over because there's nothing, there's no baby to breastfeed. وَانْقِلَاعِ دَرْسٍ. الدرس is, what's a dars? Dars. Is a tooth, right? Or a molar tooth, right? So if you hired a doctor to remove your tooth, okay, you pay him for that, and then the tooth fell off, okay, khalas, then the contract is over because there's no need for him, okay. And then he says أو برئه. Obviously here he means bur' al-marid. Or let's say you hired a doctor to come to your house and take care of a marid, of a patient. I think they used to do a lot back in the day, maybe nowadays not so much, okay. And then all of a sudden, oh my God, the patient is healed before the doctor came. Khalas, can the doctor say, no, you have to pay me, I can't? No, khalas, the guy is healed, there's no service, there's nothing for you to do here, okay. Jazakallah khair, okay. وَنَحْوِهِ. So anything that is on, that can be analogous to that. So the Ijara contract will be immediately voided in the following situations. So number one is, we said, the very thing which is hired or rented becomes damaged, okay. So example, Muhammad rents a car for 3 days, but it breaks down after 12 hours. Khalas, if it breaks down, then the contract is void. I'm not going to pay you for the rest of the contract. Question here, what about the 12 hours he used it for? Muhammad rents a car for 3 days, but it breaks after 12 hours. These 12 hours, is he going to pay for that? Yeah? Anybody disagree? Is it what? Did he get the manfaat from it in that 12 hours? He's paying for the time. Remember, we said it could be the time or the task. So he's paying for the time here. So he used 1/6 of the time, right? He rented for 3 days and he got 12 hours. So he got 1/6 of the time. So he should what? He should pay for 1/6 of the price.
But let's say I rented the car and I didn't use it in that 12 hours. After 12 hours, I wanted to start again.
Okay, so now you're saying, okay, I rented the car, I didn't use it for 12 hours, I turned it on, it wouldn't turn on. He's saying that, but in this case, you're trying to claim that I don't want to pay for the 12 hours. The only way you can get away with that is if you can prove that it was broken from hour 1. Does that make sense? Because if you wanted to use, because the landlord is not responsible how much you use it. If you rented a car, if you rented from Budget or Enterprise, and you left it in your garage for 3 days, and are you still going to be charged for it? Yeah. even if you didn't use it. حتى يعني if it stayed there, just decoration. Okay. But if you can prove that it was damaged from hour 1 and you didn't use it, then yes, you can do that. Number 2, death of the baby being breastfed. So this will void the contract with the wet nurse. And anything that's similar to that. Anything that is similar to that. These are just common examples. Tooth that was supposed to be removed by the dentist, but the patient pulled it out himself, or the patient got cured, you ordered a doctor, whatever it is. And think of some other examples. I don't know, you hired someone to shovel your snow, and then the landlord, the neighbor comes with his snowblower and cleans the holes. Okay, then he comes, you're like, khalas, okay, unless you were paying him like some monthly fee, okay, and this was agreed that he's responsible to do that, whether the snow falls or not. Sometimes you have these kind of contracts. Fadl?
Yeah, I just want to see, like in this case, if I am doing business and you book a time from my side, so you are preventing anybody else to take that time, and then in the last hour you say, okay, I'm not doing it, so I am losing.
Say it one more time. If
I am a business and you came and book a time with me, saying I need your time from 12 to 1.
Okay, let's make this just more practical. You're a barber shop. Type. Okay, so I booked a time with you for 12:30 haircut.
Yes.
Okay, type.
And then at 12 you didn't show up. You said, okay, my brother did the haircut for me. I don't need it anymore. So now.
And then I say, okay, you know what? I don't need the haircut. I'm not coming. Then you don't come.
Yes, and then I lost that period of time where somebody may take that time.
So what happens now is they have policies, right? They have cancellation policy. So nowadays, if you like the barber I go to, there's a cancellation policy. They'll tell you like you have to cancel within, I think like 6 hours or 4 hours or something like that, or 24 hours. If you don't cancel, then you will be charged for that service. Okay. So here it's more of like a wa'd. You're promising him to be there for that. Yeah, this is where there's some khilaf amongst the fuqaha about wa'd, about promising something. Is a wa'd binding? Is it like a promise binding? Because you haven't. It's not. If you sign the contract, that's different. But if it's a wa'd, I'm gonna come. What?
So when you make a contract, it doesn't need to be signed, right? Even your work, it can be. So when you go and buy something from the shop, you don't sign a contract between each
Okay,
other.
sahih.
That's the art. It's by word, right? So if that's the case, your word is like a contract in this scenario.
Now, I think it's just going to go back to the shart, to the shurut they have for this contract between them. Allah alam. Is the one who booked the appointment responsible? What do you guys think? Fadl.
I think in cases where you work as a consultant, because you have to do research before that 1 hour, you have to prepare for that 1 hour, you do actually do work
Before the actual meeting.
Before the actual meeting. So I think in some cases it should be binding or compensated.
So yeah, it could be case by case, but like I said, usually they'll have shurut or some policies about it. Tfaddal, you had something to say?
Like for a doctor appointment, they have cancellation policy.
Yeah, so you have a mudda of cancellation, like custom-wise, like urfan. There is a cancellation period, so you can cancel. But if you cancel after the time, okay, مثلا they give you 24 hours, then you are responsible to pay.
So it's not voided. This is what I'm saying. The contract is not voided in this case. You have to.
If you explain to the client, if they show up, I'll be charging you.
Yeah.
But if you didn't explain, it's
Yeah, so do you understand what he's saying? He's saying this is the asl, this is the default. If there was no stipulation, tamam. But nowadays, see, like when we talk about a lot of the uqud, okay, the mu'allif is going to tell you the general, kind of the basic general rule. And then we said in the beginning of buyu', we said shurut, yeah, وَالْمُسْلِمُونَ عَلَى شُرُوطِهِمْ, right? And so if you put conditions in the contract like this one, now in the contemporary contracts, they put a lot of shurut to avoid all these issues. They've already happened, people have already fought over them. And so they know now, okay, it's not feasible for me to just have an open booking time because I'm going to lose my time, right? And it's not, so they'll put shurut in the aqd, they'll put shurut. So like I said, and when I book my haircut, right? Here, like on 37th, I'll book, and then it'll tell you, مثلا, text message, if you want to cancel, you have to cancel within 24 hours. If you don't, then you'll be charged مثلا half of the price or something like that. They have access to your information. Information. Nah, I think that one is a bit more flexible. Yani. Fadli, you have a question?
It's like you said last week. Most of the contracts nowadays, it's implied that time is already implied. That it's more rental of time, and then maybe you can add task on top of it. It's very rare that you'll find independently it's ijara of task.
Yeah, more common that it's the ijara of waqt, of time. Naam. Less often of a task, but there are tasks. Yeah, there are any contractors and stuff like that. They'll be paid, but it's also by time. So,
but when you're doing it by task, they have to sort of specify that they're doing it.
I've personally done contracts by task. Like, مثلا, somebody one time I was in Saudi Arabia. Somebody was doing a master's. They asked me to go through it was English, to go and مثلا, edit the whole thing. And so they're like, I'll pay you this much for going through the whole paper. Okay, so the time for them didn't matter. Okay, just get the task done, and I'll pay you for that. Adi.
The asl here, like the implied asl here, is that it's a contract of time.
In which one? In which type? It depends on which task. No, it has to be known. It has to be known how you're getting. Like, what do you? That's why the manfa has to be known, and whether it's mubah or not. And then when we went into specifics about the property ones, right, or the assets, you have to make sure: am I paying you by time or by task? Like, is it by time or by task? So it depends. Like, you can rent a car just to get to Vancouver. That's I'm paying. I'm paying you for that. Or it could be I'm renting it for 3 days. It's two different. You have to make it clear when you're doing those types of contracts. Then he says, جميل. You said وانقلاع درس أو ونحوه. ونحوه يعني anything that is similar to that. Okay. جميل. Then he says, what about the liability? Who's liable now for any damage or anything like that? Look what he says here. ولا يضمن أجير خاص ما جنت يده خطأ ولا نحو حجام وطبيب وبيطار عرف حذقهم إن أذن فيه مكلف أو ولي غيره ولم تجني أيديهم ولا راع ما لم يتعدى أو يفرط. Okay, let's break this down. So he says here ولا يضمن. الضمان, we said to guarantee something or to be liable for something, right? So ولا يضمن أجير. So the renter or the lessee, the أجير خاص is the person that you're hiring for something. الأجير الخاص, he's going to talk about two types of أجير. Two types of أجير. The أجير that is like privately hired for a specific task for you. Okay? And then there's the one that is mushtarak. It's someone who does multiple tasks at the same time. Okay? They have a difference. Yeah, the fuqaha, they differentiate between them. So the ajir khas, okay, like ajir khas would be someone like a full-time employee. You have a full-time employee, okay? He's only supposed to what? Work for you. He's only supposed to work for you. Can he work for somebody else at the same time? He can't. No, until you're paying him to work for you. So the ajir khas, like let's say an employee, he does not guarantee ما جنت يده خطأ. جنت يده خطأ, and for something that happens under his hand by mistake. Okay, so I don't know. يعني imagine he's give me an example of something like an employee does. It's just a mistake, and I don't know. It costs the company something. I don't know. نعم. نعم.
The laptop breaks.
Yeah, the laptop breaks. He's typing on the laptop, and it slips from his hand and it breaks. Khata. is he liable for that? Is he responsible for that? No. Okay, he's not responsible for that. Who's responsible for that? Is the landlord. They'll talk about if there is no ta'addi or tafriq. This is the condition. So I just want you to understand. We talked about ta'addi and tafriq if somebody transgresses or is negligent. So a mistake is different than transgression or negligence. Transgression or negligence, the guy, the laptop is being slow and he's like, he's just being an Arab, he's hitting it, right? This is ta'addi, right? طيب. Tafriq could be something like, negligence could be something like, he just never, shuts, yeah, like there's a policy in the office, no drinks next to the laptop, مثلا. And he has his like mug every day there, and then one time he hits it and then it falls off. Is this a khata or negligence? It's negligence. It's tafriq because there's a policy in the office that you're not supposed to have drinks next to the laptop. Like if it's allowed to have drinks next to the laptop and he accidentally hits it, then he's not responsible for that. Jamil, just so you understand the idea. So ولا يضمن أجير خاص ما جنت يده خطأ. So as long as it's a khata, then he's not responsible. ولا, he's going to mention 3 types. ولا نحو حجام. Hajjam is the guy who does hijama, cupping, right? The cupper. Cupper, is that what they call him? Let's call him cupper. So the cupper, he's not responsible. ولا نحو حجام ولا طبيب, even a doctor. ولا بيطار. بيطار is a vet, yeah, the animal doctor, right? ولا بيطار, nor either a veteran, a vet, yeah, veterinarian. Okay. عرف حذقهم. Now he's going to mention that the conditions for those people not to be liable, these people who are hired for a specific task for you, right? These are the ajir khas. The ajir khas is not allowed to do different jobs. He's for you. So he says with the conditions عرف حذقهم. Al-hidq is to be proficient. Here it means proficiency. So if I hired you as a doctor and you ended up being an engineer, and then you messed up, okay, or something you gave caused death, he'll be liable for that. Because aslan he's not even licensed, he's not tamam. So the condition for him to not be liable, عرف حذقهم, and then he says in أذن فيه مكلف أو ولي غيره. He has to have been given permission to do this by someone who's what? Who's mukallaf. يعني what if a 6-year-old hired him? So it has to be someone who's mukallaf, who's hired him, or the wali of him, or someone who is on his behalf. ولم تجني أيديهم. Okay, ولم تجني أيديهم, and it's not something caused by their own hand through ta'addi or tafriq. And then the last thing he says ولا راع ما لم يتعدى. Okay, so ولا راع, الراعي is the shepherd, right? So if you hired a shepherd to watch over to watch over your sheep, okay, and then all of a sudden one of them drops dead, is he responsible for the sheep? He's not responsible for the sheep. Okay, but if he goes next to the the pack of wolves, okay, just to have some fun, so and then one of the sheep gets eaten, okay, then he's liable because that's ta'addi and tafriq. That's ta'addi and tafriq. I saw a hand. تفضل.
You mentioned that a 6-year-old cannot hire a doctor, let's say. We have many cases where a child calls 911 for an ambulance, and the ambulance shows up and they find out it's just a headache or a fever, and then they charge the family.
So you're saying that sometimes a 6-year-old might call 911 for a headache or a fever, and then the emergency comes and they charge the family. Is that what happens when you call 911? They charge the family, right?
They charge money.
Huh? They charge?
If the ambulance came to you, they will charge money.
طيب, all the time? Okay. So you're asking like, يعني, why should they charge?
I'm asking,
Who's liable here? Like, why does a kid have a phone? تمام?
maybe there's a phone in the family.
نعم.
I don't know, like,
If that's the law of the land, يعني, I guess, because they charge you for the service. Here, I thought you have a freebie. Like here, if you have an emergency system in your house, the first call is always like free. It's always waived. Are you sure?
Only
No, it is. Like if you have TELUS security, right? And there's a false alarm and they come to your house, they always waive the first one. Then they charge you the second one like 100 or something.
fire truck is free,
Mhm.
fire is free, police is free, not the ambulance.
Okay, interesting. I thought you always get the first one is free. But the ambulance by itself, if you call the ambulance by itself, that's like if you call the ambulance by itself. No.
The ambulance came, the medical.
Yeah. So just make sure you have, insurance.
And I think in some of the European countries, there's even fine. So
There's a fine.
let's say a child calls,
Mhm.
you don't know, you just have a fever and the child sees you unpleasant the whole day. They call the ambulance and the ambulance shows up. You don't have the emergency. Now because you took the time from someone else that
Yeah.
had a real emergency, they will fine you as well and charge you.
Yeah. What can you do? That's so the parent is responsible to make sure that the child is not does not have access to a phone. يعني It's negligence. هذا تفريط from the parents. أحسنت. جزاك الله خير. طيب, so the following hired workers in general are secure from any from any harm that may occur on the job. So they don't have daman. They don't have to. They're not responsible for anything that happens on the job. So they will not be responsible. We mentioned three types. The specific worker that does something wrong by mistake. Okay, you hired someone, your employee, and he accidentally does something by mistake, or he caused you to lose some money, or whatever it is. It's a mistake. Okay, he accidentally clicked purchase, for an item, and you couldn't get a refund. So that's a mistake. ما في مشكلة. As long as there's no negligence or transgression. Number two, doctors, vets, and coppers. Same thing. If these guys are hired specifically for you for a job, and they make a mistake, they're not responsible. يعني, I don't know. You hired the vet to مثلا, I don't know, shave your cat or something, and he accidentally he cuts his tail or something like that, just an accident, khata. He's not responsible for that. Shepherd who herds the sheep. Yeah, we said the shepherd as well, same thing. And you could do an analogy on anything that's similar to that, then they will not be held responsible. There's some details about them. So the first one, the specific worker, okay, it says here, so let's say, for example, a housemaid breaks a glass in the house by mistake. You hired a housemaid, okay? Khaddam, you have a khaddama, and she's cleaning, and oops, she hit the vase and broke and fell. Can you take that off her paycheck? Can you take that off her paycheck? Huh? No, you can't. So that's what he's saying. So you cannot take that off her paycheck. In this case, she will not be held responsible for her action. If you start finding broken vases every day, then that could be a problem. But an accident, okay, tamam. So what if she steals and you have a camera? Obviously, she's responsible for that. That's not a mistake. That's not a khata. That's tafrit. Actually, that's ta'addi, right? So if you find like a missing ring and you have proof that she took it, then of course you can hold her responsible. However, if she did so due to negligence or transgression, then she'll be held responsible. We talked about al-ajir al-khas wal-ajir al-mushtarak. The difference between specific and shared worker. Here's the main difference. The specific one provides his services just for one person and he's paid based on time. These guys, like the ajir khas, like the maid, she's paid on time. She's paid by time, right? And the shared one provides his service to multiple clients and he's paid on the work that he performs. Think like someone like a barber and other professions like that. They do different tasks, they do different jobs, or maybe an accountant, someone who does your taxes. He gets paid for different things. He does different jobs at the same time, right? And he's based on a task. Like the one who does your taxes, do you charge him by time? Right? So this is an example of a task, right? Task oriented. So he charges you مثلا $100 to do your taxes, and then he'll charge you extra for an extra T4 or whatever. So it's by task. Tamam? So in these guys, you will find out, we're going to talk about them. They will guarantee. This is the main difference to see. The ajir khas, he doesn't guarantee for mistakes. Okay? He's not liable for that. لا يضمن. Okay? But the one who is mushtarak, okay, the one who's paid by task, he does guarantee. Okay, and this is something that was practiced يعني, in the time of the Sahaba, and it's something that if you didn't have it, then there would like you just the economy would not run. Tamam? Why? Because aslan, يعني, if someone's not gonna get the task done and they're gonna be like, oh, my machine broke, or I tripped, or something, then no work will ever get done, and nobody can ever guarantee that their task gets done. Does that make sense? So let me just finish reading. So he says, وَيَضْمَنُ مُشْتَرِكٌ مَا تَلِفَ بِفِعْلِهِ. So anything that is damaged with his own actions, then he guarantees it. Tailor, مثلا, you take your thobe to the tailor, you take your pants to the tailor, and you tell him this, I'll pay you $50 for shortening my pants. Okay, you give him the $50, and then you come back and it's like he cut the pants like way shorter. They're shorts now. They're like, well, what's the? So he's responsible for that. He's like, oh, sorry, man, my machine slipped, and no, he's responsible for that. هو يضمن. Okay, he's ضامن for that. لا من حرزه ولا أجر له. Al-hirz is like something in his own custody. Okay, something in his own custody. So لا من حرزه. So he's not responsible. They're saying here, if he kept your pants in his tailor shop, and then مثلا, I don't know, there's a fire and everything burned. For that, no, he's not responsible. Okay, he's not responsible for that. لا من حرزه ولا أجر له. If that happens, he doesn't get the payment of the for the actual job. Does that make sense? So if that happens, he doesn't get the payment for the. And let's say you take your pants to the tailor and you say shorten it for it, $50. Okay, he said okay. He does the job. He puts it in his shop, and the shop burns down. Does he have the right to get paid for the service? The mu'allif is saying no. I'm sure there's khilaf in the other madhab. The mu'allif is saying no. Why? He said because Muhammad went to get Muhammad was going to pay him for the service of shortening the pants. Did he get the service done? Yeah. Did he get the pants shortened? Did he get the pants shortened? No, he didn't get no pants. Nothing. Imagine I have to pay you and I don't even get pants. Yani khalas. You lost, he lost. You know, it's yani that's how the Hanabila see it. Let's read. So he says here. We mentioned this part, right? We said this is something, I think I skipped through the slides. When we were talking about the doctors, the vets, and the coppers, right? We said they're not responsible as long as they are known for their crafts. Yani they're not just like some quack, right? And they have permission from the mukallaf. We said someone who's mukallaf has given them permission, and they were neither transgressing or neglectful. Okay, and they also mentioned the shepherd if he doesn't transgress. So now he goes to if someone is a shared worker. Yeah, ajirun mushtarak. Okay, inshallah we'll finish by the adhan. We're almost done. So وَأَجِيرٌ مُشْتَرَك, he says here, if someone is a shared worker, then he is responsible for any damage through his own actions. Okay, that's what he says here. وَيَضْمَنُ مُشْتَرِكٌ مَا تَلِفَ بِفِعْلِهِ, by his own actions. So for example, Muhammad goes to a tailor to get a suit sewn, but the latter damages, okay? The tailor damages the cloth during the process. In this case, who's responsible? The tailor. Muhammad is not responsible. The tailor will be held responsible and must compensate Muhammad. It's just like if you go to a mechanic, okay, and he's supposed to fix your leaking whatever, the AC pipe, right? And while he's doing that, okay, he breaks the whatever, what's the one called for the steering? No, the liquid for the pipe for the liquid for the steering. What's it called, man? Huh? Not the coolant. Anyways, none of us are mechanics. Anyways, he breaks another part of the car by mistake, and he cuts another. Okay, who's responsible for that? The mechanic's responsible, even though it was an accident. Tamam? So he's responsible for that. Okay, like because in the Hashia and in other books, and they'll say, by analogy, he's not supposed to be responsible. Okay, but because nothing would run like that. And technically, if that's going to happen, then you can never guarantee your task to be done. Meaning, I'm going to pay him, and then he's still like. I remember one time I was in Saudi Arabia. My Civic was the AC was leaking, and it's hot. Like you need to fix it. So I took it to this guy, and طبعا as a student you go to the cheapest guy you find. So they don't use like the latest technology. They use the soap. I know you guys seen how they do. If the flat tire, they'll put soap and they'll try to find it. Same thing with the leaking pipe, right? The Freon gas, whatever they call it, the pipe. They'll put soap and they'll try to find where it's leaking. So he fixed it. He said, "I fixed it for you. I put the gas." طبعا the gas is the most expensive part. The actual what do they call it for the AC? Huh? Freon, right? Okay. So then he gives it to me. I pay him. I take the car. Mashallah, it's cool. I go home. Wake up in the morning. It's all gone. the gas is gone. It's leaked. There was still a leak. So I go back to him, and he's like, "Oh, you have to pay me again." I'm like, "No, Habibi. I paid you for the service to fix the leak. The gas is not my responsibility. It leaked. Why? Because of my negligence? Whose negligence is it? It's his negligence." So he's like, "Khalas, I'll let it go. مش عارف إيش." Did it again the second time. I went. I'm like, "Okay, khalas." He figured it out. Wake up in the morning, and then it's not heating. There was another leak. So I take it to him. He's like angry. ومش عارف إيش. I'm like, "No, man, you have to fix it, or I'm gonna go." Eventually, he wouldn't give me my money back. Right? He wouldn't give me my money back. Until he was Pakistani, until I got another Pakistani guy to talk on my behalf, and then eventually, and he fixed it. But yeah, he's responsible for it, right? Because if he's gonna tell me that, "Oh, it's not my responsibility," then nothing is gonna. Every business owner is gonna make an excuse that, "Oh, it's not my fault," or "This happened." Because of darura here, he's the one who's damin. Okay, so it says here, however, if it was due to something that was not in his in the shared worker's control, then he's not responsible, but he will not be paid. Yani somebody robs the garage. So you left your car there. You left your car in the garage. He's fixing it overnight. It's done. He did the job. He left it overnight in the garage. Okay, and then somebody breaks in. He put his alarm. He put everything. Someone breaks in and steals the car. Who's responsible here? Is the mechanic responsible? Here the mu'allif is saying no, he's not responsible. Okay, so because it's in his custody, but this not because of negligence. It's not because of negligence. Now I don't know what's going to happen now with the mechanics who leave the cars outside. If there's some kind of agreement here or urf that it's known that he's not responsible, then ما في مشكلة. Okay, ولا أجر له. So if he fixes your car, and then he puts it in the garage, and then he puts the alarm, somebody breaks in, steals the car. طيب, is he responsible for the car? The mechanic? No. طيب, does he get paid for the ujra? No. The mu'allif says no. He does not get paid for the ujra, for fixing your car, because the guy didn't get what he asked for. He didn't get his car or the service. Okay, تمام. نعم. جميل. And then he says here. Yeah. Now he says. والخاص. Now he's going to tell you what we already mentioned. والخاص يعني the أجير الخاص من قدر نفعه بالزمن. So the specific worker, the one who's hired for a specific task, is the one who's paid for a specific time. That's the أجير خاص, like an employee. Okay, and he's the one that is not liable. والمشترك, he's paid by a task. Okay, and he's the one that is responsible, like the mechanic. Okay, so just keep those examples in mind. The mechanic is a mushtarak, he's paid by task, so he's liable. Okay, the other person, the ajir khas, he's paid by time, and so he's not responsible like a maid or a. No. So and then he says وَتَجِبُ الْأُجْرَ بِالْعَقْدِ مَا لَمْ تُؤَجَّلْ. So the ujra, if you're gonna pay a mechanic, if you're gonna hire someone, the mu'allif is saying what's supposed to happen is you pay him up front. You pay him up front, okay? Does that happen here? I don't. In some cases not. But he's saying that he should be paid up front, ما لم يؤجل, unless both of you agree not to. Okay, so the default is that he's paid up front. Here, do you pay up front for a service like that? You sign a contract, it's binding. Khalas, you pay him after. Is that what they do? Sometimes they pay half up front, half after. Whatever you agree upon. But he says the default is that you pay up front, unless you agree to pay after. Because tasks like mechanics, sometimes things come up. You're like, oh, we also found out that this was broken. Oh, you go in with one thing broken, you come out with like 6 things, right? He'll give you a list and you're like, but طبعا he needs to ask you for permission to do it before he does it. And then he says, وَلَا ضَمَانٍ. Okay. نعم.
Was those conditions changed by the offer?
نعم.
Was those conditions that for the specific and general, the public one,
About responsibility, about الضمان. Can someone guarantee? No, you can't. Well, see, because can someone write a contract and say,
even if it's specific, if you break something, it's all yours.
yeah, can you put it on them? Like, can you hire a maid and be like, for every vase that is broken, you're gonna pay for it? Huh? I guess I don't see a problem with if it's a shart and both of them agree upon it. Because does it go against muqtada al-aqd? Yani against the premise of the aqd? Does it go against it? I don't know. I think it might be a valid. I don't see anybody agreeing on that, but it could be a valid stipulation. Another example would be like what? What's a common day example? It could be. Could be something that you can stipulate in the contract. Wallahu a'lam. I don't see a problem why you couldn't. Naam?
Even if you don't put it in the contract, let's say it's the custom in this country, like you pay, when I hire you for specific, whatever you break, it's on you. So now it's the custom. This is what you know in the country.
Look at, for example, movers. When movers move your like your furniture, if something breaks, like if they hit the wall or something as they're moving in, are they responsible? Huh? By mistake? No negligence? No, I know, that's what I was going to come in. Like they pay insurance for that, right? So the movers people usually pay insurance for them. Why? Because anything that breaks from the items, from the house or whatever, they will cover for that damage. Meaning that the default was that they're not responsible for that. Unless they were negligent. Yani some guy tried to lift a freezer by himself. Okay? Or مثلا he pushed it off the car like that. I saw a video the other day. This lady, she ordered something, like I think it was like something similar to Amazon, and UPS or something like that. And she had a camera, right? So the guy came and she ordered a camera, an actual camera, like a Canon camera. And the guy, because he was in a rush, he threw the box like that, like on her front door. And then when she picked it up, she's like, she found the camera broken. Tamam. So is this negligence? Yeah, it's negligence. Tafrit. Okay. So in that case, he's liable for that. Okay, but the urf, naturally, if you put it and it's broken, the deliverer is not responsible. You would have to go back to the actual product company, the actual company, not the one who's delivering it. So
For the specific, like if I get somebody to do a certain job for a long time and he starts breaking stuff and he's not responsible.
I gave you the asl. If you hired someone and they keep making mistakes, okay, then obviously they're not proficient. Do you remember we said they have to be proficient? صح? And we said عُرِفَ حِذْقُهُم, right? So you hire someone, a maid, and and she's like, she doesn't know what she's doing, right? So خلاص, then you break the contract and you say خلاص, that's it. You were not proficient like you said. This resume is from ChatGPT. It's not real. Now,
Wouldn't it be dependent on the amount of water involved? Because in the maid's example, like a house is relatively stable. What if it's a shepherd, for example, and he's responsible for every sheep that is lost?
we said, so you're asking about Gharar. The shepherd, if the shepherd, he's not, he's responsible for all the sheep, right? Okay, type. So if something happens to them, it's not his fault. If he doesn't,
In the contract they stipulated, they sort of forced it upon the shepherd to say everyone that's lost is on you, whether through negligence or otherwise.
Yeah, so if they stipulate it in the contract, I don't see a reason why they can't stipulate it. He would have to agree to it. But يعني, it's almost يعني, for whatever reason. يعني, والله أعلم, يعني, I don't know, because that's
Because there's so much gharar that could happen.
there's a hadith. It's I can't remember it. I think I'm not sure if it's a sahih hadith. There's maybe some weakness in it, but the Prophet ﷺ, يعني, I'm paraphrasing here. Whoever hires like a doctor for healing, and he's not يعني, qualified, then he's liable. He's responsible. Tamam. So that tells us about someone who's proficient, has to be proficient. So if he's not proficient, then he's liable. But if he's, meaning, what's the mafhum mukhalafa here? Yani the understood meaning, the opposite understood meaning is that if he is proficient, he's not responsible. So from that hadith, some of the ulama will say, no, you're not allowed to force them. You're not allowed to put a stipulation that goes against the main, I guess, the crux of the contract, which is that he's not responsible. And you can't put a condition to make someone who's ameen not ameen, or the opposite. Okay, that's why I think there's a problem with that. Wallahu a'lam. You're gonna tell a shepherd, you're responsible for anything that happens to my sheep. But what if one of them is sick, drops dead? And then, one sheep is $350, and that's a lot of money. That's for 2 days of watching the sheep. It's not fair, right? This is not fair. But if it's from his negligence, yeah, it's fair. Tamam. And then the last thing he says, وَلَا ضَمَانَ عَلَى مُسْتَأْجِرٍ. This is the last sentence. وَلَا ضَمَانَ عَلى مُسْتَأْجِرٍ إِلَّا بِتَعَدٍ أَوْ تَفْرِيطٍ وَالْقَوْلُ قَوْلُهُ في نَفْيِهِمَا. He's saying here that there's no ضمان, there's no for the مستأجر إلا بتعد أو تفريط. Yeah, we said that there's no the مستأجر, he does not guarantee anything because his hand is yad amana, right? It's a yad amana, so he's not responsible except through ta'addi or tafrit. طيب, what happens now if there's something happens, something breaks? Who are we going to believe? Who are we going to believe? So you're renting the house, and خلاص, the oven breaks. طيب, who's responsible for this now? No, according to what we said, who's responsible? The oven broke. Huh? The lesser, the landlord is responsible. As long as there's no ta'addi or tafrit. Good? Okay. طيب, now the renter, he's going to say, I didn't do it. It just broke. The guy's going to be like, what do you mean? I just set up this new oven, and this. Who's the judge going to take? Whose word is the judge going to take? So he says here, وَالْقَوْلُ قَوْلُهُ فِي نَفْيِهِمَا. So the judge will take قَوْل الْمُسْتَأْجِرِ فِي نَفْيِهِمَا. So when it comes to denial, it wasn't me. Whose word are we going to take? The renter. Because the asl is that it was not his fault. That's the asl. And the default is that it's not his fault. The only way that the landlord can win the case here. So that's the thing. Like, when you're renting from a landlord, right, and you break the oven, like you threw a cup and then the oven broke, you're responsible. But if you go and you say to the landlord, listen, man, the glass just cracked, okay, and he doesn't have proof. In front of Allah, you're sinful, you're a liar, okay, and you're eating haram. But in front of the judge is going to go with the renter, unless there's proof. How are you going to prove it? I don't know. Like, it's pretty much impossible. So that's where, like, the taqwa of Allah subhanahu wa ta'ala is. So let's just read this and we're done. The lessee is not responsible for any damage that may occur unless it was due to negligence or transgression. So example, Muhammad rents out his apartment to Zayd. Okay, Muhammad rents his apartment to Zayd. Then after a few days, the water pipe breaks. This happens a lot. Water pipe breaks. Who's responsible? Okay, in this case, Zayd is not responsible, right? Zayd, the one who's renting, he's not responsible. The landlord is responsible. Oh, it costs 14,000. That's I'm paying you for rent, right? And people don't realize that, right? Just a kind of side point, yani. A lot of people, when they talk about like owning property and stuff like that, these are hidden costs that people don't think about. When we talk about renting versus owning, This is a classical debate. Forget about the whole issue about mortgage and riba and stuff like that. But owning a house, there's a lot of responsibilities. And if you're going to rent it to someone and the pipe breaks, and then it's like everything leaks, $10,000 to fix it, who's responsible? You, the landlord. It's a huge $10,000 out of nothing. So this is just like a FYI. And for those who like to argue that owning is always better, sometimes renting is better because you're not responsible for, fixing the roof. That's, I don't know, how much is it? 15K. The furnace has to be renewed, another مش عارف 10K. And, you have to, المهم, there's so many things that can happen. And then he says, if there's any dispute that arises between the lessor and the lessee as to who is responsible for the damage of the rented property, then the one who denies being negligent or transgressing will be the one given preference. So obviously here in this case, the musta'jir, the renter says, I didn't break it, خلاص, it's his word. Unless there's proof that, he actually broke it. Good luck with that, but then he's liable in front of Allah subhanahu wa ta'ala, but in front of the judge, he's not responsible. Wallahu ta'ala a'lam. تفضل, you have a question? Questions? We're pretty much done. Alhamdulillah, we finished the topic of Ijara. Our next topic, actually, next week, inshallah, we've covered all this, mashallah. We've covered. Where are we? MashaAllah. We've covered at least. So we did musabaqa, by the way, we did that. So next is al-ariya, borrowing. Okay? This is different than renting, borrowing something. Like when you want to borrow something from someone. Okay, what is the ruling? Okay, so the fuqaha, they put this chapter in the Muamalat. Okay, and also then we'll talk about ghasb. I think maybe we'll cover ariya and ghasb together. Maybe because I think they're short chapters. And then we don't have much, I'm going to try to finish all this before Ramadan, inshallah, so that after Ramadan we can start either inheritance or fiqh al-usra, the fiqh of family and nikah and divorce and all that stuff. So that inshallah we'll probably start it after Ramadan. Wallahu ta'ala. Wassalamu alaikum wa rahmatullahi wa barakatuh.